Ready, start. This is subject to the limitations prescribed in clause within bracket 5 of Article 22, full stop. That clause, as noticed above, requires two things to be done for the person against whom the order is made, full stop. By reason of the fact that clause within bracket 5 forms part of part 3rd of the Constitution, its provisions have the same force and sanctity as any other provision relating to fundamental rights, full stop. As the clause prescribes two requirements, the time factor in each case is necessarily left fluid, full stop. While there is the duty on the part of the detaining authority to furnish grounds and the duty to give the detained person the earliest opportunity to make a representation, which obligations, as shown above, are correlated, there exists no express provision contemplating a second communication from the detaining authority to the person detained, full stop. This is because in several cases a second communication may not be necessary at all, full stop. The only thing which emerges from the discussion is that while the authorities must discharge the duty in furnishing grounds for the order of detention, double inverted comma, as soon as may be, double inverted comma close, and also provide double inverted comma the earliest opportunity to the detained person to make the representation, double inverted comma close, the number of communications from the detaining authority to the detainee may be one or more, and they may be made at intervals, provided the two parts of the aforesaid duty are discharged in accordance with the wording of clause within bracket 5, full stop, so long as the latter communications do not make out a new ground, their contents are no infringement of the two procedural rights of the detainee mentioned in the clause, full stop. They may consist of a narration of facts or particulars relating to the grounds already supplied, full stop. But in doing so, the time factor in respect of the second duty, which, to give the detained person the earliest opportunity to make a representation, cannot be overlooked, full stop. That appears to us to be the result of clause within bracket 5 of Article 22, full stop. It has not been found by the High Court that the appellant knew enough English to understand the grounds of his detention, full stop. The High Court has only stated that double inverted he has studied up to 7th Hindi standard, which is equivalent to 3rd English standard, double inverted close, full stop. The High Court negated the contention raised on behalf of the appellant not on the ground that the appellant knew enough English, to understand the case against him, but on the ground, as already indicated, that the service upon him of the order and grounds of detention in English was enough communication to him to enable him to make his representation, full stop. We must, therefore, proceed on the assumption that the appellant did not know enough English to understand the grounds, contained in many paragraphs as indicated above in order to be effectively to make his representation against the order of detention, full stop. The learned Attorney General has tried to answer this contention in several ways, full stop. He has first contended that when the Constitution speaks of communicating the grounds of detention to the detainee, it means communication in the official language, which continues to be English, semicolon. Secondly, the communication need not be in writing, and the translation and explanation in Hindi offered by the inspector of police, while serving the order of detention and the grounds, would be enough compliance with the requirements of the law and the Constitution, semicolon. And thirdly, that it was not necessary in the circumstances of the case to supply the grounds in Hindi, full stop. In our opinion, this was not sufficient compliance in this case with the requirements of the Constitution, as laid down in clause within bracket 5 of Article 22, full stop.